We're apparently different in South Dakota than in North Dakota because what I've encountered is that oil and gas companies that are operating in North Dakota, and if they come into Hardin County and we talk about power lines, they say, well, no, the power company will pay for putting the power line in, and they don't. But apparently they do in North Dakota. And so the landowner of the power company, Grand River Electric, is not going to pay the landowner to put the power line in. That's going to come, that compensation is going to have to come from the oil and gas operator. If the state of South Dakota owns the surface, it's usually also going to own the minerals because the state cannot convey minerals. But there's a statute which I've cited that says if there's surface damages paid, half of those damages go to the agricultural grazing lessee and half go to the state of South Dakota. So you say you're a rancher and you're leasing some state land and the operator comes in to drill. You should get half of those damages and the other half will go to the state. The state is not, doesn't enforce that very strictly, and I've seen damages be paid 100% to the agricultural lessee, but they have the legal right to get half of those damages. You ought to talk about fencing. You know, can you fence roads? Sometimes a rancher wants them fenced, sometimes not. Fencing well sites, I mentioned. Pipelines, probably not going to be fenced. Go width and use of road easements. The reason I've got the word use in there is that you would want to restrict who can use this road. Usually, do you want the operator, the oil and gas operator, to have the ability to sublease use of the road? And if that's going to be an issue, you're going to want to cover that. Either, you know, that may be okay if you get more compensation. Maybe you don't want it at all. What's the term of the surface use agreement? And what you should do is link the term of the surface use agreement with the term of the underlying oil and gas lease and say that this surface use agreement shall continue in force for so long as the operator holds an oil and gas leasehold interest in the described land. So that so long as the lease continues, your surface use agreement continues. You obviously want to put in there obligations to reclaim, reclaim the well site once it's done, reclaim the roads, maybe not, maybe the rancher wants the road. So what you can do if you don't know is say that the rancher shall have the option of saying leave the road in or say telling the operator to reclaim it. You should go over fresh water, the use of fresh water. Where we don't, if hydraulic fracturing to the extent that it's done in North Dakota isn't done here in Hardin County. There's some done with horizontal wells. But that can be a big water user. You want to be clear that the operator can or cannot use fresh water, either surface fresh water or subsurface fresh water. You want to cover that. If they can use it, you'd want to provide for compensation. Water disposal is there I'm talking about produced water, say from the Red River B in Hardin County. That's going to produce water as well as oil, sometimes a lot of water. And usually that's going to be injected back into the Red River or some other formation that is safe to inject it into. It's not a source of drinking water. Well, do you want the operator to be able to inject water produced from other leases into your lease? Or do you want him to only be able to inject water produced from your lease into your lease premises? And if they want the ability to inject off-lease water, then you should discuss compensation for that. I haven't... what I just talked about is when the rancher owns both the surface and the minerals. And I'm saying, get your surface, or at least a part of the minerals. Even if the rancher only owns half the minerals, they're coming to get the oil and gas lease from him. he owns the surface, then that's when you should negotiate the surface use agreement for that rancher. In the instance where, say, the rancher does not own any of the mineral interest, and so all the leases are taken from probably absentee severed mineral interest owners, well, at that point it's harder for that rancher to negotiate a surface use agreement because the operator has the oil and gas leases. By law, that operator has the right to come on, explore for, develop, and produce oil or gas. So the rancher who owns no mineral interest has a significantly reduced bargaining position. But it still should be something that you could try. Yes?
So when you're doing your surface use agreement, what evaluation is in there about default and when you can actually lock them out? What do you do about that?
So the question is, what do you put in a surface use agreement about default, and when can you actually lock them out? And I have a default clause I use which says that the rancher surface owner is going to give notice of the default to the operator. They have a certain amount of time to cure it. If they don't, then the rancher's remedy is to go to court. I don't think you can lock them out because if there's an oil and gas lease, that gives the right to go on and drill, explore for, develop, produce. The surface use agreement is just a contract of what are you going to be paid for damages. If it's breached, I think your remedy is the same as for any breach of contract. You have to go to court to get a judgment. That's the end of my presentation. We'll take about a 15-minute break. We are going to have, if you've still got questions, we are going to have a question and answer session at the end. Or feel free to talk to me during the break and I'll try to answer whatever questions you have. But let's reconvene in 15 minutes. Thank you.